This video is about how to defend a dangerous dog case. It's for anyone who has a dog and who has been served with what's called a notice of intention to declare their dog dangerous. It's also for people who've been approached by the council and the council said to them that their dog's been in an alleged attack. Now it goes through a number of steps, and these steps are designed to give you the best chance of keeping your dog away from the dreaded dog enclosure, the dreaded dog cage. And what I mean by that is that if your dog is declared dangerous, you must build a cage, a dog enclosure that is in compliance with the prescribed regulations, and you must keep your dog in that enclosure at all times unless it's muzzled. So you can only take it out if it's muzzled. And I've spoken about this in a previous video called What is a Dangerous Dog? So I'm going to go through the steps now of how to maximise your chances of getting away from that dreaded dangerous dog declaration. Now the first step of course is that you will have received some sort of notification from council that there's been an alleged incident. So they might have called you and said XYZ happened. You may not have even have been there when it happened. You may have even been overseas, but council will normally advise you that an incident has occurred and they'll invite you to participate in an interview. Normally that interview won't do you any good because you normally won't have been there at the time, and also you may be under a great deal of pressure if you participate in that interview. Normally I say to people it's probably not in your benefit to participate in a council interview. So that's the first step, being notified of an alleged incident. The second step is that you will receive a notice of intention to declare your dog dangerous. That's a document that's put in your letterbox or posted to you from council, which says that council is going to issue a dangerous dog declaration after a period of time, normally 7 days. Now, you have 7 days from the date that you receive that notice of intention to draft and send council a letter of objection. Council must consider that letter of objection before it proceeds to a full dangerous dog declaration. So it's the letter of objection. We do those here quite regularly, but you can also do them yourself. And what they essentially are a letter to council saying certain things, which might include the fact that your dog has never previously been in any incidents, that it's always around kids and nothing's ever occurred, it's good with cats, it's good with other dogs. Anything that you wish to put in there that attests to the fact that your dog is not an aggressive animal. Now, in that notice of objection or the letter of objection, you can also put in a number of letters. So they're called character references from neighbours or from anyone else who's had dealings with your dog, the vets, you know, people who have kids who've been around your dog, people who've had pets that have been around your dog. You can also put that into this document. You can attach it to that document. So only letters of reference. You can also put in what's called a temperament assessment. So if this alleged incident occurs, you can go out and see a temperament assessor, and they can do some tests on your dog, and they can give you a temperament assessment, a document, a report which says that your dog is not an aggressive dog. A number of people do that. One of the good ones is a guy by the name of Steve Austin. He's on the internet. You can contact him. He has no affiliation or anything with us, so he's an independent dog assessor. There's a number of those types of people. That's a temperament assessment. Another thing you might want to do is take photos of your property to attest to the fact that it's well secured, your dog can't get out, especially if the allegation involves your dog jumping over the fence or getting out of the gate or getting off your property and doing something. So this is called the letter of objection. One of the very important things I think that should be attached to a letter of objection is something called undertakings, which we developed several years ago here at our practice. Undertakings are essentially promises to council. They're not legally binding, but they're promises to council that you will do a number of things. For example, you can undertake not to allow your dog to be in a public place unless it's on a leash. You can undertake that if your dog is in a public place, it must always be with a competent adult, so an adult, someone who's over 18 years of age, obviously. You can also undertake, for example, to secure all borders of your property and undertake to allow an authorised officer from council to come and inspect the property, and that you will comply with any suggestions to make the fencing better. Things like that. These are undertakings. We have standard forms of undertakings here, and when someone rings up for a conference with me or another lawyer here, we can email them a copy of these undertakings to reduce costs and so that they can do them themselves. So you've received the notice of intention, you've written the letter of objection, but council now issue a dangerous dog declaration. What can you do then? Well, you can do one of three things. The first is do nothing. If you do nothing, the dangerous dog declaration is effective and you have to comply with all the control requirements. And I've discussed those in a previous video and they're quite onerous. That's the first thing. You accept the dangerous dog declaration. The second thing you can do is you can appeal the dangerous dog declaration within 28 days. And the way that you do this is to complete what's called an application to the local courts, and you can do this yourself. You can go to the local court registry, your local court registry, and you can ask them for an application. You can fill it out yourself, or you can have a lawyer do it for you on your behalf. But of course, if you get a lawyer, it can get quite expensive, and if you go that way, you should really ask for fixed fees for these types of cases, which we offer here. So it's an application to the court, it's an appeal, you fill it out, you file it in the court, and there's a filing fee. It's under $100 at the moment. You give them the filing fee and you will get a court date sometime down the track. And that's normally 3 weeks, 4 weeks, something like that down the track. Now once you file that appeal, or you can also call it an application, what you must do immediately, in my view, is to try to negotiate with council to revoke the dangerous dog declaration, to get rid of it, as long as you comply with what's called control orders. Now, control orders are similar to undertakings. They're promises to act in a certain way and to control your dog in a certain way, but they will always be less onerous than a dangerous dog declaration, because they will almost invariably leave out the enclosure requirement, which is the requirement that your dog stays within a cage. So these are control orders. We draft them here as well, and if you have a first conference with us, we can provide you with a precedent for control orders. Now, you may be thinking, why would council refuse the undertakings and then later on accept control orders? I mean, if they're essentially in the same form. The reason is, whereas undertakings are not a legally binding document, control orders are. And the Act, the Companion Animals Act, talks about control orders, and it also talks about the repercussions of breaching any control orders. Control orders are legally binding, and what occurs is, so your dog is declared dangerous. You send control orders, proposed control orders to council. You ring them up or you email them, you try and negotiate these. They may ask for extra control orders to be put in there. For example, your dog must be muzzled when in a public place. They may ask that. So you negotiate. There's a bit of argy-bargy in these cases quite often. However, if you come up with a resolution with council, it's the best thing for you, the best thing for your dog, and council is protected because those control orders must be rubber stamped by the court and they're made legally binding by the court. Normally they'll last for 12 months or 2 years, whereas a dangerous dog declaration will last forever unless you apply to after 12 months to revoke it. Okay, so these are control orders. This is step number 2. You try to negotiate these control orders with council, and if you have a lawyer, your lawyer will go into court. You won't have to be there, and we'll come to the agreements. The agreement will be handed up. You do A, you do B, you do C, you do D. The magistrate will simply say the dangerous dog declaration is revoked. In lieu thereof, that is in substitution thereof, these control orders come into force for a period of 12 months, 2 years, whatever it might be. It's a very, very good resolution. So if you do have a dangerous dog declaration served upon you, you may want to try to negotiate control orders to get rid of this dangerous dog declaration. The third thing you might want to do is to wait 12 months, because you can also appeal against a dangerous dog declaration after 12 months. If you don't do it within 28 days, you can wait and you can do it after 12 months. And you wait, and the way you do that is to write to council and to tell council, look, I've done X, Y and Z, I've taken my dog to Barkbusters, or I've had some type of behavioural training, here's the certificate, my dog is a lot better now and it's very unlikely that this will occur in the future, please revoke the dangerous dog declaration. So after 12 months you can give council these documents and ask them to revoke the dangerous dog declaration. If they don't revoke it, you can go through the steps to which I've already referred, that is, doing an application to the local court after 12 months. So what if you or your lawyer on your behalf comes to the first court date and you haven't been able to reach some sort of a resolution with council for control orders? You have two choices in that situation. The first is to accept the dangerous dog declaration. In that case, the dangerous dog declaration will be put into effect and you can't appeal against that until 12 months after it first came into place. That's the first choice. And the second choice is that you can ask the court for what's called directions. Directions means that we, that is the appellant, that is the dog owners, we must serve council with any documents by a certain date, any materials by a certain date, and a lot of those materials will already have been served with undertakings and or with the control orders. So we've got to serve it by, for example, by 15th of January, and the other side, council, will normally have to serve their documents within a period thereafter, often 2 weeks thereafter, so by the end of January. It's very unfortunate, but it's often the case that it's only at that stage where we know their case. We have their statements, their photographs, the medical records and all that sort of stuff. They don't have a legal obligation in these types of cases to give it for them, but they often do so as to counteract any claims for legal costs down the track. Anyway, what occurs is the court makes directions and the matter comes back before the court to see where we're at. Eventually it will go to a hearing. Now, I try to avoid hearings at all costs because it can be very expensive, it can be a little bit messy, but if it does go to a hearing, what occurs is that witnesses take the stand. For example, the complainant, the person who was bitten, would go up on the stand, or allegedly bitten, would go up on the stand and say what he or she saw. Then I could ask them questions about what occurred, and witnesses will go up on the stand one at a time. The ranger would normally go up there, and in these types of cases it's often the case that you would go up on the stand and you would say what occurred if you were there, or talk about anything that you'd like to talk about that's relevant to the case. That's called a hearing. At the end of the hearing, the magistrate would decide whether we are successful in our appeal, that is, we successfully have proved that the dog is not dangerous within the meaning of the legislation. That's what a hearing is all about. Again, you should try to negotiate these cases very, very early, in my view, at the undertaking stage, or very shortly after you lodge the appeal, in order to bring about a resolution that's best for everyone, particularly your dog. Now, as I so often say in these types of cases, I'm a criminal defence lawyer, and if my client is in jail, so if they're in jail on bail waiting their trial or whatever it might be, they know why they're there. Whether they're innocent or guilty, they know why they're there. Unfortunately, in these types of cases, your dog will not know why you've all of a sudden had to put them in the cage outside the house when they previously were inside the house being loved by their family. It's terrible. These types of cases can have devastating consequences on your dog, which is why we try so hard to get these dangerous dog declarations revoked.